and I'll call the case after that.
Yes. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice Bill Meade and Peter Rubin. The first case on our list for hearing is case number 2020-P381, the Commonwealth versus Noel S. CRUZ. You may begin.
Good morning, Your Honors. My name is Jennifer Appleyard, and I have the privilege of representing Noel CRUZ on this matter. The first issue which I would like to present to the court is the lower court's denial of the motion to suppress. The findings of fact are reviewed for clear error, and the documentary evidence and constitutional issues are reviewed by this court de novo. The denial is problematic for several reasons. First, Officer Chadbourne lacked reasonable suspicion to stop Mr. CRUZ. This is an objective test.
Can I ask you a question? Did you raise lack of reasonable suspicion in your motion to suppress?
Attorney Busso in the motion to suppress used the general language of
Probable cause.
I'm sorry, what?
He argued probable cause was lacking.
And then he used the general language regarding constitutional violations. Furthermore, on, I believe it's page 8 of the decision by the trial judge, they referred specifically to reasonable suspicion. So I would suggest, since I'm arguing based upon the findings, that that was located in the record below. In the event, we're in a unique position because we have the video, which we can look at, which tells us exactly what the Officer Chadbourne was looking at the moment, and he was thinking about what was going on. I would ask the court to look very carefully at this. The facts, as they indicate, show with not particularly great quality an individual shopping. It is not clear what Officer Chadbourne states, that it's not clear from the video because of the varieties of imaging that what he says happened, in fact, happened. Therefore, I would suggest to the court that you are in as good a position as the motion judge to make a decision. And I would suggest, based on a number of cases,
doesn't both Chadbourne and McLaughlin, they see him first acting strangely, deer in the headlights, and then he sees him put something in a glove and put it in his jacket, I believe, or otherwise conceal it. And importantly, he doesn't pay for it at the checkout counter, where he's very nervous, and then they don't stop him until he doesn't pay for it. So and the judge credited all of that.
Well, I would suggest, if you look at the video itself, it is not particularly clear. And
are you asking us to take a de novo review of the evidence?
Of the documentary evidence, the video, yes.
But we have testimony, as Justice Meade has observed.
This court also, though, can look at the video and can make its own determinations. And so I'm suggesting to
determination as to what the witnesses saw. We can certainly assess whether the video clearly depicts what they testify that they saw with their eyes, but that doesn't allow us to make any determination about whether what they say they saw.
In the event, I would suggest that in the event that this court looks at the video, the court would agree that the findings made were clearly erroneous.
I guess my difficulty with that is that as we discussed, we have not seen the video, so we'll have to look at the video. But your description of it suggests that it does not clearly demonstrate what the officers say they saw. Are you suggesting that when we see the video, it will clearly establish that what the officers saw, what the officers say they saw, they did not see?
From my review of the video, I could not clearly see any of it. Did not appear clear.
That is a different question. The video, in order for us to adopt your premise, the video would have to unequivocally negate the veracity of the witness's testimony, right?
Yes.
Okay. Well, we'll see whether it does that. I've seen a number of surveillance videos. They are sometimes helpful, but most of the time they're fairly indeterminate.
I may have this wrong, Ms. Appleyard. Did either of the witnesses view the placement of the cheese in the glove in the pocket with their own eyes, or they saw it on the video?
They saw it on the video, Your Honor.
And the recording we have is going to be the recording of exactly what they were looking at on the screen. Is that right?
Correct. It's a unique situation, but yes, that's when loss prevention specialist McLaughlin was going to the bathroom is when he noticed Mr. CRUZ have a strange twisting arm motion, and that's located on pages 10 and 17 of the motion to suppress transcript. That is what triggered the telephone call to the security room where Officer Chadbourne was watching the varieties of screens, and he located the individual. But Officer Chadbourne's observations are solely made from the video, which the court will see.
Who stopped the defendant outside after he had passed the point of sale?
Officer Chadbourne stopped him.
And immediately asked to see his glove, right?
The testimony, there's conflicting testimony on that from what McLaughlin said and what Chadbourne said. So, but I believe the judge credited Chadbourne's testimony that he produced a ball of cheese at that point. Yes.
No. I'm asking about whether he asked to see the glove. You're saying the video will show it's hard to tell what's going on. We're going to have to judge the credibility of the two people's testimony that they saw him put something in a glove. If in fact they asked to see his glove as soon as he left the store, then presumably that corroborates their statement that that's what they understood themselves to be seeing on the video, right?
I'm trying to remember the end of the, I don't know, I don't have a clear recollection of the end of the video. I just know that he's stopped. There's a portion of the video prior to him being stopped where it just goes down and looks at the feet and the floor of the store. So it doesn't clearly follow him leaving the checkout to when he was stopped by Officer Chadbourne. So I'm not sure of what image it is, but the court will see it on the video if it's, I just don't recall, I'm sorry.
There's more than just the video here, because he also lies to Chadbourne before he's escorted to the office about where he got the cheese from.
Yeah, the Commonwealth did raise that, and I would suggest that if the Commonwealth did not have reasonable suspicion to stop him, then that point, there was a constitutional violation.
Let me ask you this. If someone is seen in a store placing something, concealing something on their person, not paying for it, and leaving the store, why isn't there probable cause to believe that they've shoplifted?
In this particular case, I don't.
No, I want you to answer my question.
If an officer or if a loss prevention specialist observed someone take something that was the store's and then leave,
And
then
conceal it, not pay for it, and leave.
arguably, yes, that appears to be shoplifting. Yes.
Yeah. Yes, it does.
I would just, so I would suggest that the standard of probable cause wasn't satisfied. I recognize one of the cases that I rely upon, Justice Meade, you have a dissenting opinion on, and I acknowledge that the proposition for which I rely upon is not your position, but I think in looking at Chin Clark, 97 Mass App Court, 604. And I recognize that in your dissent, you wanted to look more at the officer and the officer's expertise. I would say in looking at this from an objective standpoint, the majority holding in that case would apply. Moving on to the finding of probable cause, my argument clearly is if reasonable suspicion wasn't satisfied, then there was no probable cause. But in the event the court gets to that issue, I would suggest the primary case, Commonwealth versus Crane, 469 Mass 24, would be what I would rely upon. And I think that in this particular case, there was a hunch, but I don't think that that's enough to get us to probable cause. Moving on to the impermissible burden shifting in the closing argument, I would point to the court that this was objected. It shifted the burden of proof. And as a result of that, the Commonwealth regrettably invited the jury to infer Mr. CRUZ's guilt based upon the statement.
His guilt of what?
I'm sorry.
His guilt of what?
His ability to not present evidence of his Fifth Amendment right to not present evidence.
I understand, but the evidence went to what guilt of what charge, and it was evidence of what proposition?
Well, the Commonwealth was suggesting that he needed to put forth a reason why he was in pain. And the argument was,
which went to the question of distribution, right?
It went to the, yes, whether it was trafficking or.
But he was acquitted on that charge. The question of his possession was really not in dispute, right?
The defense did not challenge that, but nonetheless, if there's a constitutional violation,
we still look to the question of whether there was prejudice, whether it had any effect on the jury's assessment of the elements, right?
We look at whether or not, yes, there was prejudicial error.
And there was no question that he was in possession, right? No reasonable question for a rational fact finder based on this record.
Well, I think that because of the fact that it, I recognize what the Commonwealth's argument is, and I would.
He admitted to possession of the oxy in his opening statement.
Right.
The defense was to not have him be convicted of trafficking. Yes. And
I also wonder why this isn't entirely collateral to what was really at stake here, because whether he was in pain or not is not actually a defense to possessing oxy. Yes?
The Commonwealth statement, I would just suggest, is burden shifting. I recognize that the court may have a difference of opinion. I just,
Whether it's burden shifting or not, let's assume that it improperly shifted the burden, just for the sake of this discussion. And again, it's not clear to me how it has any bearing on prejudice to the defendant.
I would suggest that because it was objected to, then it needs to be shown harmless beyond a reasonable doubt. And in this particular case, I understand the court and the court's concern, but I would state that we don't know, and it's possible that it did have an effect on the jury.
All right, I see that your time is coming to an end. Is there anything further?
Nope, I rest upon my brief. Thank you so much.
The Commonwealth.
Thank you very much. May it please the court, Kenneth Steinfeld for the Commonwealth. My argument is very, very simple. As the defense counsel said when he argued the motion to suppress, if you believe that the footage shows the defendant stuffing an item from his shopping cart into his glove, then placing that glove into his jacket, and then leaving the store without paying it, then you have probable cause, and that's the ball game. It did, and it is. When the court gets the footage, it will see for itself. And as to Chief Justice's point earlier about the testimony of the officer as opposed to the footage, it is clear to me that he describes exactly what is on the footage. There's no divergence there. And this court will agree, I hope and expect, that it is very, very clear, if not unequivocally clear, although there is a white barrier. There's a poorly placed barrier. There's a column that blocks a little bit of the shopping cart. But you can tell by looking at the footage, that he's standing there. He looks around incredibly suspiciously, which I think anyone who sees that would say that. And then he clearly takes something from the top of his shopping cart. We don't know what the item is, but it doesn't matter. And he shoves it inside his glove. And then, as I said, he picks the glove up off the top of the shopping counter as he's walking down the aisle, and he stuffs it into his right hand pocket. And that gave Detective Chad Bourne both reasonable suspicion to detain him and probable cause to search him. And of course, there are other factors here that also tend toward finding a probable cause, but that's all we need, I think. But there is the fact of the officer's experience, the fact that it was the most shoplifted Stop and Shop, I'm sorry, Shaw's, I was afraid I was going to say that, in the whole company. And I know that the high crime neighborhood argument is not held in high favor, but I think this is a perfect case in which it is fair to apply it, because the SHC has talked about the connection between the specific location and the specific type of criminal activity. And here we have a closed universe, which is the Stop and Shop, and the crime of shoplifting. That's exactly what occurred here. I think also this case presents a highly instructive contrast as to what sort of conduct does not constitute a probable cause or reasonable suspicion. If you look at the first footage, the first clip, when the store loss prevention officer, Mr. McLaughlin, is walking toward the bathroom, he sees the defendant making a suspicious motion, sort of a turn and a twist and a torque, but he doesn't see anything else. And I would argue that's a classic example of no probable cause. And if you compare that to the footage that shows him later stuffing something into his glove, that's a perfect example of probable cause. As to the burden shifting, I don't have much to add. Oh, first I should ask if any members of the panel have any further questions about the first argument.
Was reasonable suspicion raised in the motion to suppress?
No, not at all. But I addressed it in my brief because I think it's a fairly simple thing to answer. But no, at the oral argument and in his motion below, defense counsel just argued the lack of probable cause. So,
Can I
the
ask?
court-
Oh, no, I'm sorry. Go ahead, please.
oh, no.
The only question I have is sort of a metaphysical one, and it's about the search in the loss prevention office.
Yes.
I understand that there's testimony that the judge credited that people who steal things, shoplift things, often shoplift more than one thing. And of course, we have this gentleman who the cheese has been retrieved from the glove, and then he's turned over yet another thing in the loss prevention office, and then he's searched. Is there probable cause to believe that he has yet a third item on him?
Yes, I think so, based on the testimony that, more than one does not mean no more than two.
No, that seems clear, but you couldn't arrest him for the possession of the third item, could you? You don't have probable cause in the sense of enough information to arrest
I'm sorry,
someone.
the third item?
Yeah, let's say the third item for some reason was a different crime. The third item was more valuable or something.
I'm sorry, I'm not following. The third thing they found was the pills.
Yes, okay, in this case it was the pills. I'm just asking about a regular shoplifter.
I see.
Turned over one thing or caught with one thing, turned over another, and now they want to search him. Now, I understand in Massachusetts, at least, this isn't a search incident to a lawful arrest.
That's correct.
Although I would have thought that that's kind of the rubric under which something like this would fall, because I get that you have certainly reasonable suspicion that this thief has more things on him, but probable cause to believe he does seems higher. It doesn't seem like an unreasonable search, but I just have a hard time with the probable cause phrase. Do we have cases saying that you can search a shoplifter for additional items?
Not specifically, no, but the probable cause I think still exists. He could have anything anywhere on his body that he's taken from the store, for the mere fact that they almost always take more than one item. Yeah. So I don't think that the officer, and I did not raise search incident to arrest on appeal because the Commonwealth failed to raise it.
Yeah, and
so that's obviously
it's quite narrow under state law. I think it might federally. I think it might, this might be search incident to lawful arrest, but I don't think it is where he's going to be released and isn't arrested.
Well, Mr. Steinfeld, in a search incident to arrest circumstance, the search can precede the arrest, correct?
Yes. Yes, but it's got to be roughly contemporaneous with it.
Yes.
And it was here.
Was he arrested or released?
He was arrested. He was taken straight to the police station.
He was. Okay.
Yeah. So
okay, no problem.
And
I didn't realize.
Yeah. And he placed him under arrest. And well, first he called the other officer, Officer Alexander, who's a pharmacist, who came and verified that those pills were actually Oxy, and then he placed him under arrest. And he brought it. But he said very early on that he was not going to let him go. That was clear from, I think, when he went out to talk to him in the first place. So yes, he did arrest him and take him back to the station. If the members of the court have no further questions, I'd be happy to rest on my brief. I'd also enjoy any more metaphysical questions that anyone would like to ask. They are among my favorites.
I appreciate that.
Well, neither metaphysics nor epistemology. Are you? And you're going to rest on your brief with regard to the burden shifting question?
Yes, I did vaguely mention it, but I actually should just say for the record, the prosecutor did not tell the jury that the defendant was obligated to produce evidence in support of his case, but rather merely commenting. I'm sorry, he's not obligated to provide an alternative explanation, but here he just commented on the lack of evidence in the tapes that were in evidence that he suffered from that he possessed the pills for personal use to treat his chronic pain. I think it was a perfectly acceptable rebuttal to the defense's argument. His whole case was that these are for personal use for his chronic pain. So I think to make that comment about the video that there's no evidence of pain on it was perfectly acceptable. And as has been pointed out, there was certainly no prejudice at all because he won the case as far as he was concerned.
Okay, nothing further. You may rest on your brief and the case.
I apologize. Just one moment, please. The case is now being recorded.
The next case on our list for hearing this morning is case number 2020-P542, the Commonwealth versus Jeremy McKenna. Attorney Bianchi, you may begin.
Good morning. May it please the court, Attorney Joanna Bianchi on behalf of Jeremy McKenna. This is an appeal from a conviction of carrying a dangerous weapon in violation of Massachusetts General Law 269, Section 10B. Mr. McKenna is a sole business owner in February of 2018. While working within his business, he was working in the wee small hours. When he was trying to wrap up his inventory, he heard a bang on the window while he was talking to his girlfriend on the telephone. He opened the door, he yelled, "Hey." Those individuals then rushed Mr. McKenna, punching, beating, kicking him, throwing him to the ground. At some point, Officer Finn arrived on scene. The discovery regarding this information was requested. None of that information was provided to defense counsel. I moved to dismiss based on the failure to provide discovery. There was a continued verbal exchange between Mr. and the assailant. Mr. McKenna, bloodied, battered, blood coming down his face, continuing to engage in a verbal argument. At some point, Officer CRUZ arrived, whereby Finn indicated he called for backup. That's unknown because no turret tape was provided since no discovery was provided to counsel. And again, there was a motion to dismiss filed for failure to produce that evidence. At some point, this verbal exchange continued while Officer Finn and Officer CRUZ, at some point, the blood and saliva from Mr. McKenna's mouth had spat in the general direction of the officer, landed on him, and then officer then rushed Mr. McKenna to the ground. They arrested him. As a result of the search incident to the arrest, he was searched and items were found on his person. Mr. McKenna was then charged with assault and battery on a police officer, resisting arrest, 2 counts of carrying a dangerous weapon. Mr. McKenna was acquitted of all charges other than the darts. The throwing darts are per se not a dangerous weapon. They are, and there is no indication that these items are inherently dangerous. The Commonwealth never had an expert witness indicating that these darts that are unique to my client and my client only are inherently dangerous. Moreover, the facts in this case are differentiated by other cases indicating that these items are not dangerous.
What insight do we have from the evidence into the purpose for which Mr. McKenna carried them?
Recreational.
Is that what I thought there was evidence that he said that he was carrying them for self-defense?
That comes from the police officer, if the police officer is to be believed, and he testified he uses them as throwing darts.
No, but the officer, but his statement to the officer is certainly it's admissible, and so the only question is whether the officer's statement was credible. But for purposes of our review, we view the light in the most favorable, in the light most favorable to the Commonwealth, and credibility is for the finder of fact in any event, right?
Agreed. Even if the statement in light most favorable to the Commonwealth was true, there was no immediate threat to the police officers. These were secured items, secured in a case on the person. They were not easily accessible. They were not used. There was no conduct.
Possession doesn't require an imminent threat. The only question is whether they were dangerous as used, right?
And we have no expert testimony or forensics to even indicate that an item that is not considered dangerous per se, per fact, indicates that. So we then
well, it can be, Attorney Bianchi, it can be per se or as used. So what would be the purpose of affixing sharp metal object to one's wrist as a means of self-defense if they could not be dangerous as used?
Because the items are recreational and used by Mr. McKenna for a recreational purpose.
That doesn't view the evidence in the light most favorable to the Commonwealth, as the Chief Justice just pointed out.
Could you repeat the question, Your Honor?
We have to look at the evidence in light most favorable to the Commonwealth, not the light least favorable to the Commonwealth. So in the light most favorable to the Commonwealth, he used them as a means of self-defense, not for recreation.
And there was no indication from the facts in this case that that even occurred.
An object doesn't have to be dangerous as used and also be employed as such.
I understand, but in this situation, he's attacked by individuals. The items are never taken off of his person to help him while he's being kicked and beaten to death on the floor. They're never used. They're never brandished. They're never put anyone in reasonable fear, imminent fear. There's no actions or anything that the defendant did regarding these objects that he either used them for self-defense, used them for another purpose, used them in a dangerous purpose. When we look at cases, we look at the totality of the circumstances. These items never left my client's person. They were never used.
Under the crime for which he was charged, 269-10B, he has to have been arrested for committing a breach of the peace. He had a weapon on his person, and he was aware he was carrying it, and it was dangerous. So none of the things you just mentioned are any of the elements of what the Commonwealth had to prove, other than it being dangerous.
Well, actually, Your Honor, he was charged with 2 counts. He had a knife on his person, and he was acquitted of that charge. He was acquitted of the breach of the peace. So the only item that he was found guilty of is the darts. And I say, had this proper discovery been turned over to defense counsel prior, and there was a chain of custody, you would have seen that these items are secured items, just like the knife. They were encased.
What showing did the defendant make in support of the discovery request to suggest that the object of the discovery, in fact, was in existence? In other words, the suggestion is that they wanted to find out whether one of the attackers was a confidential informant working with the police. Was there any showing in support of the evidence of a reasonable basis to believe that one of the attackers was a CI?
Well, we filed a motion for a subpoena requesting all that information. No action was taken by the judge.
Listen to my question, please. My question is, with your motion, was there, what showing, if any, was there just a basis to believe that one of the attackers was a confidential informant?
We had the individuals on videotape, and we had all of the information turned over to the Commonwealth, and we had requested additional information via subpoena.
I know what you requested, but in order to have that request acted upon favorably, you need to make some threshold showing of a reasonable basis to believe that the reason you're giving justifies the discovery. In other words, it has to rest on something other than speculation or conjecture. What basis was there in support of the motion to suggest a reasonable basis to believe that one of the individual was in fact a CI?
We had investigators who had researched the matter, and we had located evidence that this individual was a CI. We had photographs.
But can I, Attorney Bianchi, can I ask you, this discovery issue, I'm trying to figure it out because you did mention turret tape as well. So it looks to me like 2 weeks before trial, a Rule 17 subpoena was issued, which is not the proper way to do discovery in a criminal matter. You use Rule 14 and you make a motion. Still, even if we pass that formal distinction, there's no affidavit attached to it that says this is why we think there is such information in the possession of the Commonwealth. Rule 14 requires, or Rule 13 really, requires an affidavit to accompany any pretrial motion where you need to demonstrate some fact in order to succeed on your motion. And you're asking for this information, but there's nowhere that I can see in the record where you explain what you just said to us. I see nothing that says we hired an investigator who found X and Y and Z, and that's why we think that there is such an agreement. And indeed, at trial itself, I don't know who counsel was at trial, but counsel repeatedly says, I have a good faith basis. The only one that's mentioned is that they chat with each other, apparently the police and these people, on the video, and the judge looks at that. I don't know if we have the video or not, but the judge concluded, I gather, at least implicitly, that wasn't enough to show that these people were, either of them was a confidential informant. Am I missing something from the record that demonstrates, where you demonstrated to the court some basis for wanting such an agreement or even thinking one existed?
The investigator actually came to court, and we offered to have him voir dire to supply that information, that in fact this individual was a confidential informant. Moreover, in the voir dire would have offered, which he was not allowed to, that this area actually was under surveillance that evening, and that's how the police came on scene.
Where would I look in the record to see this offer of an expert's voir dire? It's not mentioned in your brief, I don't think. Where is it? Is there a transcript?
It was at trial, and then this case took over a year to get to trial because we continually asked for discovery. The case.
All I see is 2 weeks before trial, this subpoena. I don't see continual asking for information about a confidential informant. I just see 2 weeks before trial, a subpoena.
There were communications between defense counsel and the Commonwealth, back and forth. There were
Okay, so you get to trial and you say we need this. I saw counsel saying, I have a good faith belief. I did not see counsel saying, please allow me to put this investigator on the stand. He'll explain to you how we know it. Where would I find that in the transcript?
I don't know if that's in the transcript.
Well, you said
other than
now you said you offered and that the judge would not let the person take the stand. Did that happen?
The individual did testify at trial. We did have photos, we had evidence, and we were not allowed to show or discuss any of that within court.
I'm not asking about at trial where there was no foundation. I'm asking about your discovery request. I'm trying to figure out if the judge was told there's some evidence that supports this and the judge refused to hear it. Did that happen?
Yes, because
Where is that in the
we
record?
have-
That's
it
what
would
we're
be
asking.
regarding the video, and the person who had that information, which is Mr. McKenna's father, who did investigation, and he also testified at trial.
Wait, the investigator is Mr. McKenna's father?
Yes,
So it's an amateur investigator.
this is what he does in a living. For a living. He's in my career. He's been the best investigator I've ever had with the amount of information that he found.
Okay, and I didn't see you. I understood that you said the video showed it, and I gathered the judge looked at the video, right?
He did not look at the video in its entirety. Other pieces were not allowed to come in.
He looked at the part where they had a conversation prior to entering, right?
I believe so.
Okay. Great.
I see that your time is coming to an end. I think we're going to have to leave it there unless there are further questions from the panel. Okay.
So
Thank you.
so at this,
Attorney Yasanowski for the Commonwealth.
Thank you, Your Honor. May it please the court, David Yasanowski, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. Your Honor, before I get to the meat of the argument, I would like to clarify one point counsel made about the record. First off, counsel on appeal was trial counsel. And as the court pointed out in questioning, she was given repeated opportunities, both at trial and beforehand, to provide a good faith basis for her discovery allegations. She never did so. I would also point out that counsel stated that this was a professional investigator who testified. On page 231 of the first volume of the transcript, I asked Mr. McKenna Sr. whether he had ever testified at trial before, and he stated he had not testified as an investigator in any trial. Counsel also, during that direct examination of Mr. McKenna, was given multiple opportunities to lay foundation for her claims that the individual in the video was a confidential informant and repeatedly failed to do so. As to the question of the dangerous weapon, the evidence presented at trial was sufficient for a jury to find that the darts on the defendant's wrist were dangerous as used. Counsel does not dispute the first three elements of the carrying a dangerous weapon charge. The only question is whether those darts that were carried on the defendant's wrist were dangerous as used. We also, of course, don't dispute that they were not dangerous per se. There were four specific areas of the record that show that those darts were dangerous. And first off, there were the darts' physical characteristics themselves. And the jury was able to review the darts in three-dimensional form, but the court also has a photograph of those darts as they were submitted to the jury. As the court can see, those darts are 4 inches long and they're made entirely of metal with sharp tips. This is different from the recreational darts which are mentioned in the case that counsel cites from Illinois. Although the defendant testified in his case that he used these darts recreationally, the inference that can be drawn from a review of the way the darts themselves look is that those darts are not for recreational use. Further, the dart's location on the defendant's person is another area of the record that the court should consider that shows that the darts were dangerous as used. The darts were on a sheath on the defendant's wrist in a way in which he had easy access to them. All he had to do was take his hand and move it over to his wrist to grab them. Now, in Commonwealth v. Bradshaw, the court pointed out that the ease of access to a weapon is one of the areas that the court considers when it comes to whether or not that weapon is dangerous. The weapon in Bradshaw was a knife, which was unsheathed and sticking out of a defendant's backpack in a way that he had easy access to the handle. And much as that knife, the darts here were in a location where the defendant would have easy access to them and were sticking out in such a way that the defendant could easily handle them. The defense counsel points out that these darts were in the sheath while the knife was unsheathed. Given the full facts of the record, that comparison is too mechanical. If the darts were unsheathed, they would not be affixed to the defendant's wrist. That sheath was necessary for those darts to be on the defendant's wrist and thus for him to have access to them. And next, the defendant's actions, both immediately before and during the arrest, also helped the trier of fact find that the darts were dangerous as used. The defendant was involved in a violent interaction at 2:30 in the morning in downtown Lowell. It was so violent that when the first police officer arrived on scene, he felt the need to call for backup. And that officer testified that his primary concern was his own personal safety as he awaited for backup to arrive. Unlike the other two parties who calmed down once the officer arrived, the defendant continued to be aggressive towards the parties and towards the police. And of course, ultimately, as defense counsel stated in her argument, spit from the defendant's mouth hit one of the officer's face. After that, when the officers attempted to arrest the defendant dragged two police officers between 10 to 15 feet into the storefront as they were attempting to arrest him. And while doing so, he was wriggling and trying to get out of their reach. The inference from that is that these darts that were on the defendant's wrist were readily available to him to use should he have been able to gain access to them. And finally, as the court pointed out in defense counsel's argument, the defendant's inculpatory statement about the fact that the darts were used for self-defense factors in favor of finding that they were a dangerous weapon per se.
Can I ask a question about the discovery issue?
Yes, sir.
Was there a mandatory discovery turned over to the defendant, not including obviously this CI stuff, but was there anything turned over? Do you know?
Yes, Your Honor. So if I may go outside the record on that, in this case, the discovery that existed were the written police reports, which defense counsel, of course, received, as well as the physical evidence, which was in the custody of the police station. Counsel had raised an issue of chain of custody of the darts and had been invited to come to the police station and view the physical evidence. I don't believe that that had ever occurred. I will say that during the trial itself, Justice Crane held a brief voir dire about the darts based on defense counsel's claim that they were from a different case and made findings about the fact that these darts were the ones that were confiscated from the defendant as a result of this arrest.
Can I ask you this? If one of the people outside the store were a confidential informant for the police, do you agree that and obviously we don't know that he was because there's been no evidence of that put in, so far as I can tell, with the exception of whatever little conversation, or I say little, whatever conversation they can be seen having on the video. I don't know if we even have the video, but I gather the judge looked at that. If one of them were a confidential informant, should that information have been turned over in mandatory discovery?
Yes, Your Honor. Well, first off, just very briefly as to the video, what both officers testified to is that they had begun trying to gather information from those two individuals when the altercation occurred. So the judge was able to view the video, which was about 2 or 3 seconds worth of conversation, but also was able to hear the officer's testimony about what that conversation was about.
And there's no audio on this video, right?
That is correct. There is no audio. It's surveillance video from Lowell cameras.
Okay.
In terms of the agreement with any potential confidential informant, first off, I understand this is going outside of the record, but as the trial prosecutor, this is not just the Commonwealth disputing that we should turn that over. There is absolutely no information that would lead us to believe that this is a confidential informant. And both officers testified that not only did they not know this individual, they didn't know that he worked for Lowell PD.
Okay, so, but my question was, if he had been a confidential informant, you would have been obligated to turn that over do you agree that you would have been obligated to turn that over as part of mandatory discovery because of Brady and so on?
Yes, Your Honor. I think we would have at least had to clarify that he was in fact a confidential informant.
So nothing prevents defense counsel, if she thinks he's a confidential informant, from bringing a motion for a new trial, if she has some evidence, and putting it forward and trying to prove that you didn't give them valid discovery, right?
That is correct, Your Honor. And would also give her
the standards obviously will be what they are, but or if it were ineffective assistance of counsel or whatever, one could imagine avenues to go down. But nothing was presented here for purposes of the direct appeal. No evidence was presented to show what the good faith basis was.
That is correct, Your Honor. And I actually believe that Justice Crane made findings of fact about the fact that there was no credible evidence regarding.
Can I ask you a question? When you say you'd reveal that one of these people may have been a confidential informant, are you talking about revealing his identity?
Well, that is part of the problem, Your Honor, which is that the Commonwealth is not aware of the identity of those individuals. Now, counsel, the defendant's father claimed to know that one of those individuals was an individual named Jason Sayer. And
well, see, the problem with what you told Justice Rubin is that a confidential informant's identity is privileged. And it's very difficult to have that identity revealed in a drug case, in which this certainly is not.
Yes, Your Honor. I think if I can clarify what I was saying, the discussion of what extent of information should be revealed to defense counsel needs to be prefaced by some sort of showing that there's anything to reveal at all. And here, this is not just the Commonwealth saying that we should not have to reveal this information. The Commonwealth is saying that there is no information to reveal. The Commonwealth isn't aware of who that person is. We're not aware of who Jason Sayer is, and we're not aware of any deal between that individual and the Lowell police.
Well, and most importantly, for purposes of what we have before us and what Judge Crane had before him, there was no showing to suggest that there was a basis to believe that that any one of those individuals was a confidential informant.
Yes, Your Honor. And also, I know the court raised the issue of voir dire. I point out that the Commonwealth made the objection to lack of foundation on the defendant's father's testimony. So the option to voir dire was with defense counsel, to voir dire the witness to lay that foundation. And despite repeated opportunities to do so, that did not occur. And I would suggest that the reason that did not occur is because there is no evidence.
Can I ask, was there somehow an offer of having the father put in testimony or do a voir dire that wasn't permitted?
No.
I didn't see that in my, okay.
What there was, Your Honor, was there was an objection to lack of foundation by the Commonwealth repeatedly when the defendant's father attempted to bring up this information. And at sidebar, Justice Crane again and again inquired about the good faith basis for the defense's arguments. If there are no further questions, I would rest on the brief and ask the court to affirm the defendant's conviction.
Seeing no questions.
The case is now being recorded.
Okay, the next case on our list for hearing this morning is case number 2020-P64. It is a criminal matter and an impounded case. And I will say that the panel is going to take a brief recess at the conclusion of this hearing before we resume with the balance of our hearing. With that, Attorney Magicomo, you may begin.
Thank you, Your Honor. Please the court, Joseph Giacomo on behalf of MS. For the Commonwealth to prove MS criminally responsible, they must prove beyond a reasonable doubt that at the time of the alleged crime, either MS did not suffer from a mental disease or defect, or if he did suffer from a mental disease or defect, MS still retained the substantial capacity to appreciate the wrongfulness or criminality of his conduct. I would point out at the outset that voluntary intoxication does not provide a basis for a claim of lack of criminal responsibility in this case. I would suggest to the court that the events before the incident, and post-incident indicate that MS was not sane. The evidence would suggest that MS suffered from a long, sporadic history of mental illness to include bipolar disorder and auditory hallucinations. Days leading up to the incident, there's evidence that MS became escalated. On July 31st, he was rapping in a car, was speaking quickly and speaking excessively. I think most notably, on August 1st, MS had an emergency appointment with a psychiatrist where he presented with pressured speech, disorganized, grandiose thinking. The psychiatrist changed MS's medication. And interestingly, the medication that MS was on at the time, the antidepressant, was known for triggering the manic episodes, which I believe I would suggest to the court is what happened in this case, it was known to trigger those manic episodes with people with bipolar disorder.
Attorney Giacomo, and I'm sorry for mispronouncing your name earlier,
That's
but
fine.
you, in your brief, you recognize that ultimately this question of criminal responsibility is a question of fact, and your challenge on appeal is to the sufficiency of the evidence to establish that fact. That means, and again, as you say in your brief correctly, we view the evidence in the light most favorable to the Commonwealth. What you are ultimately asking us to conclude is that no rational fact finder on this record could have concluded that he understood the wrongful nature of his conduct. Is that correct?
That's correct.
I mean, certainly, as you've identified, there were indicia that he had a troubled mental condition. But there were also indications, were there not, that he recognized that what he was doing was wrong?
I would suggest to the court that I would believe it, although there was a lack of testimony brought out during the trial with reference to this issue. It's pretty well known within the court system that bipolar in these manic episodes does not, in and of itself, prohibit the individual from post-incident recognizing what happens. It is generally recognized within the medical field that there can be a foggy recollection of what transpired, but that in and of itself does not rise to the level of having a conscious insight at the time as to what is happening. And I would suggest
Can I ask you this? He admits that it's wrong to steal someone else's chain. And when the police came to investigate, he lied and said he was not at Benny's, which would indicate not only consciousness of guilt, but his consciousness of his wrongdoing, because he's trying to cover it up.
Post facto, yes, and that is common with bipolar individuals that go in and out of a manic episode. I would suggest to the court that the mere fact that post-incident he recognizes it, admits that he did something wrong, and has some foggy recollection of the incident.
I understand the argument, but I'm not aware of a single criminal responsibility case where there's evidence of what exactly the defendant knew at the time he committed the crime. Instead, we have to look at the circumstances and draw inferences based on what was said and done, and including what was done after the fact.
I would agree with you, Judge, and to that point, even with the medications, MS was still exhibiting delusions, bizarre, fixed false belief, auditory hallucinations, irritability, aggressiveness, impulsiveness. On the day of the incident, he believed he was being filmed for a movie. He was rapping. He believes he heard Brown say, "I'll take your chain." Someone calling out for him to grab Officer Elliott's guns. So I would suggest to the court that if you look at the overall picture of this individual within the time frame of the incident and post-incident, where most of the charges are coming from out of the hospital, that it would suggest that he was in a manic state. This is the middle of August. You have an individual laying in the middle of a hot pavement parking lot at Benny's. He initially does not approach the alleged victim as the alleged victim's walking through the parking lot, just calls out "Tommy boy," only approaches him as he's coming back. And most poignantly, I would suggest to the court that his actions in and of itself suggest that he was in an unorganized state of mind. He engages in a conversation with the individual. He grabs the chain.
Mr. Giacomo, I assume, I've not read the full transcript, but I assume that the trial counsel made exactly that argument to the judge who tried this case. This was a jury waived trial. Is that correct?
Yes, and interestingly, Judge, the Commonwealth did not present any evidence contrary to the defense's evidence through Dr. Robertson.
Right, but the ultimate question is for the trier of fact, and what you're asking us to do is to conclude that that there was no rational basis for the judge to have reached the conclusion he did on the basis of the conflicting evidence that he heard.
Well, I would suggest to you that yes and no. Yes, you're right with reference to that, except for the fact of conflicting evidence. The only conflicting evidence that I would suggest the Commonwealth pointed to was, well, it seemed he may have been intoxicated. And intoxication in and of itself, as I stated, does not negate a finding in this case.
It's not, when I say, I realize that there was no opposing evidence. However, as you've described, even here on appeal, you've characterized the defendant as slipping in and out of manic conditions. And as Justice Meade pointed out, the question is what his condition was at the time he committed the criminal act. That ultimately is for the trier of fact based on the indicia that were present in the trial to determine whether he was capable of rational processing at the time of the act or not.
Right, and again, I would suggest, Your Honor, that the overwhelming evidence suggests that he was not. Even if you were to summarily eliminate Dr. Robertson's testimony, which it seems the judge did in this case, the Commonwealth still has the burden to prove the sanity. And no part of Brown, Welch, or Elliott's testimony, I would suggest, surmounts that heavy burden. His actions at the scene, staying after he had the altercation, pulled the chain, grabbed the watch, and saying, well, this watch is mine now too, staying around while the alleged victim in this case called 911 and not immediately fleeing, and then his actions within the hospital, both with Officer Welch and Officer Elliott, believing that there was a gas leak that would blow up Welch's house, becoming aggressive, increasing in tone and frequency, would suggest to, I would respectfully suggest to the court, is evidence of the fact that both at the time of the incident in the Benny's parking lot and even more, the incident at the hospital suggests a manic state, and the Commonwealth was not able to surmount its burden of persuasion in exhibiting that it was not. I don't know if I lost you.
No?
Okay.
Further?
So with that, I would rest on my brief unless the panel has any further questions. It's a fact-driven argument, and again, the facts I would suggest to you show that the judge did err in his finding.
Thank you. For the Commonwealth?
May it please the court, Brian Fahey on behalf of the Commonwealth District Attorney Timothy CRUZ, the appellee in this matter. As Your Honor pointed out, the standard of review is sufficiency of the evidence. I would suggest that the Commonwealth had met its burden in this particular case, that there was more than enough evidence to find the defendant criminally sane at the end of the facts presented and the evidence presented at trial. And I would suggest that the lower court, Judge Sullivan, made the proper ruling. To briefly answer the Chief Justice's question, the defense attorney in the lower court did reference in his argument the laying about in the Benny's parking lot. That was in the trial transcript on June 21st of 2019 on page 34. So that certainly was considered. There's no question that the defendant's behavior was aloof, or if you were to use layman's terms, crazy in some ways. But there's still that threshold that you have to meet to be not guilty by reason of criminal responsibility. In this particular case, there were several facts supporting both prongs in that potential test, both with the ability to conform the defendant's conduct to the law, as well as his awareness of his appreciative of the wrongfulness of his conduct. With respect to the wrongfulness of his conduct, I would point to instances where the defendant in this particular case accuses the victim of committing an assault and battery on him, knowing that what the victim did to him in his mind was wrong under the law. Clearly, this was as a result that surfaced after the attempted taking of the victim's chain. But in addition to that, the defendant in this case stated to the victim that he was going to call the police on him, which shows further awareness that an assault and battery is something that would trigger a police investigation, appreciating the wrongfulness of that conduct. And this is contemporaneous at the time where all of this is happening. It's not afterwards when he's speaking to the doctor. I believe it was 6 or 7 months later. And I defer to the transcript with respect to the time frame there. I'm sorry, sir.
So there's several crimes for which he's convicted here. I'd like to focus on attempting to grab the gun from Officer Elliott.
Certainly. I think that when he was in
testimony from an expert, you don't have to believe it, but we have testimony from an expert that he had an auditory hallucination where a voice said to him, grab the gun. He believed he was in, according to the expert, he was in a public service video of some kind about why you should always have 2 police officers, not 1, with someone who's mentally ill. And the expert has also testified that it is very difficult to resist an impulse from an auditory hallucination. And in this case, I'm just focusing for the moment on the grab the gun auditory hallucination.
Certainly, Your Honor. With respect,
my question is, yes, well, I mean, I guess you're going to answer it anyway, but I'm trying to figure out how someone, judges know, we know nothing about this, or if we do, it's happenstance, right? I don't know. I wouldn't have said mania itself renders one, and no one is saying it does, renders one not criminally responsible, but this goes beyond mania, I think, with auditory hallucinations and so on, and delusions. So, although that could be part of it. So, how can someone find beyond a reasonable doubt that the grab a gun, he recognized the wrongfulness of the conduct and was able to conform his behavior to the law?
What I think, as Your Honor had acknowledged, he knew grabbing the gun was wrong, so we can put that aside for now. I think the important thing with that particular issue is when you focus on the grabbing of the gun, the defendant in this case alleges that he heard a voice, not multiple voices, he heard a voice and the voice said, get the gun. And notably in, I believe it was the cross-examination in the transcript from the lower court district attorney, assistant district attorney who cross-examined the doctor in this case, she conceded that the defendant never acknowledged any consequences or repercussions for not following the so-called orders that this voice was giving. So there wasn't this mental compelling of the defendant that he must grab the gun. It was just, I would suggest, a voice suggesting grab the gun. There were no dire circumstances that would happen if he didn't grab the gun. So he knew it was wrong, and he wasn't compelled to do it because he didn't fear any consequences or repercussions for not listening to these voices. So I think that's where we went to that. In addition to that, I'm sorry, Your Honor, go ahead.
testified that her professional opinion was that he could not conform his behavior to the requirements of the law. And it's not clear to me, I am not an expert, it is not clear to me whether the reason people are compelled by a voice to do something is fear of consequences, or just some psychomotor issue. You know, I don't know how compulsion works exactly.
Let
So
me
I hear what
back up, if I may, just for a moment, because the source of the suggestion that he heard a voice was what?
Was the defendant himself to the doctor, who then testified about that.
And there was evidence in the trial, was there not, that indicated that the defendant initially was not making these claims, but when he realized he wasn't going to get bailed, began complaining of head pain, and and he also had some level of experience. In other words, he was aware that if he claimed that he was hearing voices, it might give him an opportunity to raise this very defense. Is that correct?
That's correct, Your Honor. He actually referenced the fact that he believed that 90% of the crimes he's committed in his life, however many those were as a result of mental health. He disclosed this to the doctors, which left 10% that he presumptively or deductive reasoning believed that weren't as a result of mental health. He also
an actuarial probability. I mean, ultimately, the question of whether the defendant's assertion that he was hearing a voice was one of credibility for the trier of fact. Is that
certainly? And our suggestion is, once you get past the Lattimore standard, which we believe we certainly did in this case, that's up to the trier of fact to decide, which was Judge Sullivan in this case, and he could weigh those suggestions or those assertions against, by using his own common sense, which the cited case law allows, to use common sense to use lay testimony.
My question is about the Lattimore standard. How can a non-expert judge find, oh, this expert, the Commonwealth has put on nothing to counter it. This expert has said he heard voices, she finds it credible. It's hard to control yourself in response to that based on her experience and training and so on. How can the finder of fact get to the point where, well, I don't have a reasonable doubt about his mental competence?
Because the
that's the problem that's the problem that I mean, I have this problem with this whole thing. This seems meant right. So
if the defendant had not waived his jury right, that question of fact would have been determined not by a non-expert judge, but by a lay jury.
Yes, unless it shouldn't go to the jury because there's insufficient evidence. But that's what I'm trying to figure out, is if this is going to be a meaningful standard of any kind, how can we be sitting here saying, oh, he's a malingerer, I've decided he's lying? What do I know about that? The expert says the opposite, but I don't have a reasonable doubt. I find it very difficult to understand how this is supposed to work, frankly.
I understand Your Honor's concerns, but I think that you look to O'Brien, where the fact finder need not accept uncontradicted evidence, let alone contradicted evidence, which we have here.
Aren't we saying that the presumption of sanity is enough to get us to beyond a reasonable doubt? There's a case that says that doesn't count.
I think that in the cases I cited, it's that presumption in addition to other factors, which I think we are well above that burden here. We have an individual who's distanced himself from the crime. He's lying about being at the crime scene. He's admitted to the wrongfulness of his conduct.
No, the chain, I'm not focusing on the chain.
We're talking about the gun. So with the gun, I would suggest that the issue...
Grabbing the gun, because that seems like the one that is hard to know on what basis one would conclude that the doubt raised by the expert isn't reasonable.
Because I think with that, you have to look towards the, again, the fact finder need not accept the contradicted testimony of the expert alone. In this particular case, we have the expert herself stating that the defendant cited no compelling reasons or no ramifications for the failure to act to that voice. So therefore, this voice, I think, presumptively, where the fact finder is analyzing this, could be merely a suggestion, or he was also free, if he wanted to, based on the other facts in this case, suggest that maybe he didn't have control of that. But I think there's enough corresponding facts that he can weigh in this particular case, where he can make a decision, just like a jury could have decided had the defendant elected a jury trial versus a bench trial.
Mr. Fahey, in order to establish that the defendant did not lack criminal responsibility, do the cases require the Commonwealth to put on an expert?
None. No, the Commonwealth need not put on any expert whatsoever. And I cited those cases in my brief. There's plenty of comparison cases I have here. Commonwealth versus Benson, Commonwealth versus Kapler, Commonwealth versus Lund, Commonwealth versus Cada, Commonwealth versus Koska. These are all cases that have similar elements where the defendant is showing some sort of awareness of his actions, the wrongfulness of his conduct, his ability to conform. I would suggest that in the present case, we have far more factors alone here than most of these cases have. Some of these cases have, for example, Kapler, I cited I jotted down 8 different factors here that the court looked at. You have a case like Benson, which is only 3. Here, I think we have multiple factors that a trier of fact was able to properly analyze once this case gets past the Lattimore standard, which is in the light most favorable to the Commonwealth. And I believe we have certainly met that burden.
Am I correct that a few days after the crime, the Commonwealth itself had the defendant committed?
That may have been true, Your Honor. I would defer to the transcript. However, I think that was a couple days after the incident, on the date where the defendant was complaining of his head injury. After he realized he wasn't being bailed, the hospital itself did not only did they not commit him or hold on to him for a medical reason for pain in his head, they also didn't commit him, which they had the right to under, I believe it was, I could be wrong, I believe it's section 12.
Okay, but you committed him 3 days later, 2 days before he goes to his shrink, who's like, whatever's going on here is no good, right? We got
well, perhaps the lower court did. I don't know if the DA's office did. I would defer to the I wasn't focusing on, but I would defer to the transcript, obviously. But I think that's a couple days after, and counsel himself is alleging, and I'm not disputing the fact that this individual could be coming in and out of manic episodes or whatever. However, at the time, we're focusing on the date of offense and the time of the offense. We're not focusing on days before, days after. We're focusing on that moment in time. In the best, you have Officer Welch at his doorstep within a half hour. You have Mr. Brown, who's with the defendant while he's being robbed of his chain. So we have this evidence to go by versus playing sort of Monday morning quarterback, if you will, by looking back after the fact. And with that, I would rest unless there's any other questions. I see there's a minute left.
Seeing no further questions, thank you both for your argument. The case is submitted, and we will be in recess. We will resume at 11:25. So we will open up the YouTube live stream. I will call the case. The case is, of course, as all of our hearings are open to the public, and we will go from there. Matt, let me know when we're ready to go.
Okay, I will. The case is now being recorded.
Thank you. The next case on our list for hearing this morning is case number 2019 P1425, Citizens for a Safe Chatham Airport, Inc. and others versus the Chatham Airport Commission and another. Mr. Zalesnik, you may begin.
Thank you, Your Honor. May it please the court, Ira Zalesnik for the plaintiffs' appellants, Citizens for a Safe Chatham Airport, Joseph Tischler, Michael Thompson, and David Bixby. I'd like to start, Your Honor, with what I think is the key to the case, which is the regulation contained in 14 CFR section 105.21A, which in essence prohibits skydiving from taking place over or into congested areas. Chatham is, without question, around the airport, a congested area. And my brother admitted so much in proceedings in Barnstable Superior Court, where he noted that the population is densely situated all around the airport on both approaches. And in the summertime, indeed, the population of the town soars to upwards of 35,000 people. This is a heavily populated area. This is not a suitable area for skydiving, as demonstrated by the federal regulation that I just cited. The trial court entered summary judgment based on the doctrine of federal preemption. And I would suggest to the court that preemption is not warranted in these circumstances.
Mr. Zamolowski, before we get to the question of preemption, I've been struggling as have been going through this case with question of, I don't know whether to call it ripeness or case or controversy, but this, as I understand things, this suit was brought to enjoin the issuance of a request for proposals that if it attracts responses, could result in the awarding of a contract, which could, if all necessary approvals are obtained, then result in the commencement of skydiving, commercial skydiving operations.
I'd suggest to.
Why is this case ripe?
I'd suggest to the court that the sequence that you just described is not quite accurate. Indeed, the RFPs issued, responses were received, and the last step in the process was the award of the contract. And that's the stage that we were at when the suit was brought.
Okay, but
so that I think it's more than at that point just a hypothetical.
All right, let me just ask, for example, imagine a bucolic suburban community outside of Boston with a very large farm that is used as principally for open space, and a residential developer like Toll Brothers negotiates an option to purchase that farm, or is in negotiations for an option. Isn't this akin to a group of abutters enjoining the execution of that contract rather than raising their concerns at the subdivision approval process stage?
No, Your Honor, because at that point, upon the signing of the contract, as shown by the past practice, that's all those efforts are complete, and there's no further process to go through before the skydivers start jumping from the planes.
I thought maybe I misunderstood, but your reply brief makes reference to some certificate of authorization that's required for skydiving operations to occur.
The certificate of authorization is contained in the regulation that I cited, but that certificate of authorization, as shown in the record, is in reality a special events type of authorization, so that when someone wants to, on a single occasion, skydive into Gillette Stadium or Fenway Park, they can secure permission for that jump in that circumstance.
Let me try a different tack. I mean, suppose you were citing earlier to FAA regulations, which you contend would prohibit the operation of a skydiving activity at this location. Certainly, if that's true, you would have the ability to compel the FAA to enforce that regulation. If it's not correct, then that's a different question. But the absence of the FAA from this proceeding, the absence of any current activity, I mean, you responded to this question of ripeness in your brief by identifying cases where the actual injury doesn't have to be in place in order for an injunctive relief to be appropriate, Sullivan versus the trial court among them. But in Sullivan, at least, the circumstances presented a much more direct, immediate risk of injury than what we have here, as far as I can understand things.
I respectfully disagree, Your Honor. As shown in the past, once that contract was in place, they started skydiving and started skydiving on a regular basis. There was no certificate of authorization applied for or issued as the FOIA response from the government says.
I understand that, but if a certificate of authorization is required, then you have recourse to insist that that be obtained. If it's not required, then that's not a basis to complain that one was not obtained.
We have no recourse to the FAA, Your Honor. The FAA has not done anything with respect to either these proceedings or a whole barrage of complaints to the FAA in the past.
No, but if they are the enforcement authority and it is, according to their regulatory framework, as you contend, illegal for this activity to occur, then the fact that they have not performed that oversight is beside the point. Your recourse is against them, not against the award of the contract. I'm just, I'm having difficulty understanding why this question is either right or whether we've got the right parties here.
Well, even the grant assurances that the town relies on and the FAA relies on to support skydiving in this circumstance, even those grant assurances require the airport sponsor, which in this case is the town and the airport commission, to enforce the FAA regulations. So the town is a proper party in this circumstance because they have responsibility to enforce and operate the airport in a manner required by law.
And we don't have, there's not exclusive jurisdiction in the federal courts over the preemption question, right? I mean, if we were to find that, in fact, there is no preemption against your nuisance suit and you were to win the nuisance suit, all of which remains to be seen, presumably someone like the skydiving company or a skydiving company could then bring an action against Chatham in the before the FAA, and we might get a different ruling on what the scope of federal law is in a formal proceeding. But that wouldn't be, we don't need to have the FAA here, and we don't need to be a federal court to do this, right?
That's correct, Your Honor. We, assuming that there's no preemption, which we contend that there is no preemption, the state court has ample authority to act in these circumstances. And going back to the Chief Justice's question, the whole purpose is not to require the harm be done before proceeding to challenge the action taken. And here,
again, I'm going to.
But for standing purposes, doesn't there have to be a non-speculative injury? And for declaratory judgment, there also has to be a breach of a duty that the town owed to the corporation. What is the non-speculative injury, and what is the duty?
The non-speculative injury is the injury that took place in 2012 and 2013 when skydiving was conducted on a regular basis and demonstrated to the population, indeed, that the activity itself constituted a nuisance that ought to be enjoined.
So I guess, first of all, those were you have individual plaintiffs. The corporation has no cognizable legal interest that I can recognize, and the injuries that you allude to don't seem to implicate any interest enforceable by the corporation. Is that correct?
No, the courts in the insurance agency case where an association of insurance agents brought forward a complaint recognizes that there is standing amongst an association where they've all united for a single purpose.
Can you
I
tell
don't
me
have the
again-
exact citation in front of me, but
Can you
that
tell me
was the case.
again what the injury? Judge Meade asked about the injury. The injury is it's a nuisance, but that's actually a legal conclusion. The injury is what? It's the screaming as they fall out of the plane and the profanity. It's the risk of a plane crash or of a damage to, what exactly is the injury to any of your associational members, assuming there's associational standing based on their standing? What is the injury?
The injury, Your Honor, is all of the things that you mentioned. When a person jumps out of a plane, there's the risk that the parachute will fail. There's the risk that there can be an accident along the way. And in effect, you have a person acting as a 400-pound bomb coming down on their homes and heads.
So we would have to find, though, that there is really concretely a risk of these people landing on your members' property rather than on the airport, right?
Yes, and that happened in the past, as we show in the record.
Okay, let me ask.
On a single occasion, that does not constitute a continuing nuisance, does it?
There were at least a half dozen such circumstances, plus, Your
Wait,
Honor,
a half a dozen instances where a 400-pound bomb, to use your description, landed in someone's backyard? I would have read about that.
landed off the property.
But I'm talking about your clients, the plaintiffs in this action, are contending that they have suffered an interference with their use and occupancy of their property. And I want to know, and it's a little difficult. I see the joint statement of agreed facts, but the joint statement of agreed facts includes a variety of general characterizations and disputes regarding the characterizations with reference to a number of exhibits that are not included as part of the record. So I don't have any basis in the record that we have here to evaluate specifically what injuries the plaintiffs rely on.
Well, in addition to all of the risks of skydiving, which I just outlined briefly, Your Honor, and those risks are all discussed in more detail in the Fife report that's in the record. The plaintiffs were prevented from the use and enjoyment of their property with the screaming and yelling that took place on a continuous and continuing basis during that period of time, where they were forced indoors as a result. That, as well as all of the other risks cumulatively, is what poses the damage here.
Can you point to the record to identify the detail that substantiates that general characterization?
Of the screaming?
Of any of the injuries. I mean, I don't see the factual basis for this, and you know, there would be, I would expect, some degree of noise and other annoying aspects inherent in the operation of the airport, quite apart from any skydiving.
The parts of the record include the affidavits of all of the plaintiffs.
Where are those?
Those are in volume 3 of the record appendix, volume 3 of 4. The Fife report, I believe, is in volume 4. The record is replete with specific factual assertions as to all of these difficulties. And I'll note one further one, Your Honor, even though I note my time has expired. The NTSB in their report noted that there were severe risks with skydiving aircraft that are generally poorly maintained, older aircraft and resulted in many, many accidents around the country. That NTSB report, which is attached to the Thompson affidavit, is absolutely damning, and there's been nothing done since then.
Thank you, Mr. Zanosi.
Thank you.
I have a question.
Oh yeah, I have a question too. You want to go?
You didn't get a chance to answer it. It wasn't your fault, but for the declaratory judgment, you not only have to have standing, you have to show that the town breached a duty. What is the duty that you claim was breached here?
The town, we would suggest, was obligated to run their airport in such a manner so as to protect the public interest and not harm the public interest. And by inviting skydiving at the airport, they clearly harmed the interests, not just to my clients, but the citizens of the town as a whole.
Can I ask one more question?
Yes.
I want to follow up on Chief Justice Green's initial question about ripeness. Tell me exactly where we stand in terms of what has to happen between now and someone jumping out of an airplane to land at Chatham Airport that makes this ripe for an injunction right now.
What has to happen, Your Honor, is for the town to act on the responses to the RFPs that they received, and those and award the contract. And once they award the contract, the operator is ready to go.
And is it
as shown in the past.
Is there anything in the record that shows that people have responded to the RFP with contract proposals?
I believe the record shows that they had 2 responses to the RFP.
And do we have any knowledge of whether they are compliant with whatever limited restrictions are in the RFP? That is, that a contract will, I mean, I'll ask your brother this as well, that a contract will, in fact, if this suit goes away, be awarded?
We are not sure of that, Your Honor. I don't believe that they actually opened and analyzed the RFP, but my brother would know better than that.
Thank you.
Thank you. Mr. Casella.
Good morning, honorable members of the court. From the town's perspective, we view this particular situation as a textbook example of conflict of laws. To the points that the justices had previously raised, as you know from review of the pleadings, we have raised myriad defenses to this particular complaint. Everything from immunity provisions within the Tort Claims Act to the Massachusetts elements to establish a nuisance claim, the hypothetical or speculative nature of the damages claimed. As the record shows, however, the judge in the Superior Court relied exclusively on the conflict the conflict preemption basis to enter summary judgment on the town's behalf. We feel we have very compelling arguments on all of those other grounds. Unfortunately, we have just never had a judicial determination of the merits of those particular arguments. But we do feel very confident that the conflict preemption basis upon which the lower court entered summary judgment is well-founded and is warranted in this situation.
Can I ask you a question as an aside before you get too deep into that? Isn't nuisance an intentional tort?
It is, Your Honor.
So why wouldn't the town have immunity from that?
We've argued that. No court below. In 2 motions to summary judgment and in our summary judgment, I'm sorry, 2 motions to dismiss and in a summary judgment.
But you wouldn't have immunity, that's immunity from money damages. You wouldn't have immunity from injunctive relief, right?
That's the argument that has been asserted, Your Honor. This is a somewhat unusual nuisance claim in that what it seeks is to declaration that a nuisance exists based on the circumstances. The plaintiffs have not asserted a money claim within their 258 count, which is typical and it's very unusual.
But the town's action here is action to award a contract. The regulatory authority that we are told should prohibit this and does not is not implicated here. But more importantly, the operator itself is not present in this action.
That's correct, Your Honor.
We don't have an operator because we haven't awarded a contract yet.
That is correct. This particular action, together with the request for injunctive relief, were filed pretty much on the eve of the date upon which the two proposals that were received by the town were to be opened and reviewed. So we had not gotten to the point where the town could make any substantive determination on whether to award the contracts.
But you had solicited contract proposals, you had received 2 of them, and presumably if one of them meets your requirements, you will award it.
That's correct, Your Honor.
I'm just trying to figure out if this is ripe or not. And I assume there's a way to get injunctive relief, maybe I'm wrong, before anyone jumps out of an airplane. And before, from your perspective, before someone spends a lot of money advertising their services as a skydiving place and people show up and so on. I'm not sure I'm right about that. Do you think there is a way to get an injunction? Let's pretend that this were to be found a nuisance and not preempted. Why isn't it ripe? What is it they have to wait for exactly for their complaint to be ripe?
We don't think they meet any of the grounds to establish a viable nuisance claim, Your Honor.
That's a different question. I'm asking about ripeness.
I would agree, there is no claim currently ripe before this body because no contract has been awarded. The town, what the injunction did seek to do, however, was preclude the town from taking that next step of awarding the contract. So,
I guess the difficulty I have is that to the extent that the claim is based in nuisance, the town's activity does not, and as Justice Meade pointed out, cannot constitute an actionable nuisance. The action of the town that is being challenged is the action of awarding a contract, and the awarding of a contract is not a nuisance.
That's correct, Your Honor. The appellant's argument is that based on past skydiving activities at the airport, the mere fact of awarding a contract per se would, in effect, resurrect or create prospective nuisance conditions.
Oh, wait, go ahead, Judge.
I was going to say, by the operator to whom that contract is awarded and who conducts those activities, it seems to me that at that point, then you've got, even if nobody actually jumps out of the plane, but then you've got a right party, then you've got somebody who is the proper target of a nuisance suit, and then you've got activity being conducted by that party. The awarding of a contract, again, it's just difficult for me to identify that as an actionable nuisance by the town.
That is the allegation in the complaint.
I'm sorry, I don't understand what you're saying here. The town is a property owner, among other things, right? Presumably, it is subject to at least equitable actions if it does something that's a nuisance, right?
I would suggest that that would be true, Your Honor, to the extent that that would not be preempted by a conflicting and contrary federal law.
No, of course. I'm just talking about the general question of whether a nuisance action may be maintained. So if there were no preemption, presumably you could sue, and people started flying over the thing and they're screaming and landing and doing all these things. Maybe then a landowner can sue the operator, but also the town for permitting this on their property, right?
I believe we don't dispute that the provisions of General Laws, Chapter 258, the Mass Tort Claims Act, do apply here. That does subject the town to potential liability for nuisance under the cases cited. And whether or not it entering into a contract per se could be considered to be a nuisance action, I think is a very legitimate question. We contend that that would not be.
Well, for example, we don't know that you're going to award either contract. I don't know what the requirements are. Do they have to pay you something?
It's a concession that would be awarded through the airport manager, Your Honor. The town would not receive any direct funding from the contract, no.
So someone can just show up and fill out a thing and say, I want a contract. I want to do this at your airport. And if they're whatever, if they have an airplane and whatever you need to do, the guy who's trained to teach skydiving or something, they will get the contract.
if they qualify. And as I'm sure your honors have read in the briefs, the reason the RFP process proceeded as it did is because the Federal Aviation Administration demanded or required.
Okay, so now can I ask you about, I know this started as a case about preemption, and maybe it still is, I can't tell. But if it is, or you did suggest actually that we might, that if we think it's not preempted, we might let the trial court in the first instance look at your other defenses, including ripeness, standing, and so on, although some are jurisdictional, obviously. All you had was an informal proceeding before the FAA. So there's nothing to defer to on our part. So now we just look at the regs and the statute to see if there is preemption. And what seems to be, I mean, you say the judge said conflict preemption and did not identify what statutory provision created the conflict. You do a lot of talking about field preemption before you get to conflict preemption. And I don't know enough about field preemption. I have to look into this further, but it is clear that you retain proprietary rights. You can limit noise, for example, within certain parameters. That suggests to me that the field isn't preempted. There is some room for you all to, and state law, whatever, town ordinances, whatever, to still have some force and effect. If that's true and there's not field preemption, I take it the conflict preemption is with the assurance about unreasonable discrimination, which in fact mirrors a statutory prohibition on unreasonable discrimination. Why is it unreasonable discrimination, if we have to reach this question, to not allow activities at your airport, whether skydiving or otherwise, that create a nuisance, but to allow activities at your airport that do not create a nuisance? Why isn't that, if you want to call it discrimination, perfectly reasonable?
Your Honor, I believe the simple answer to that question is the town has a contractual obligation pursuant to the grants that has been given by the FAA. And under federal law, it is the FAA has a mandate to enforce those contracts, including the grant assurances, Grant Assurance 22 in particular here. Thus, we have been the subject of not only an informal proceeding by a former skydiving operator, Skydive Cape Cod. Skydive Cape Cod has asserted an action in Barnstable Superior Court, which is currently pending and has been stayed by agreement of the parties, wherein it is asserting that the town does in fact have a federal law obligation and a contractual obligation to award it the contract. Furthermore, the FAA, this matter has, as you can determine from the filings, has been going on for years. The town has certainly taken heed of the citizens' concerns, complaints. Nonetheless, we have been directed and mandated by the FAA to proceed with the course of action.
Well, I've read the FAA filings. I find them a little bit hard to explain. The aggressive tenor of them about skydiving operation at a tiny airport on the Cape seems a little heavy-handed to me, but I'm not an FAA regulator. I don't know what they face or what they've read or whatever, or what the rules are. But yes, in that informal proceeding, and then there was some kind of CEC that you entered, although I don't see that in the record, that we have a copy of it anyway. That's all fine and good. But that's not, we have to construe the federal law. Those are not entitled to deference because they're in an informal posture, as I understand it. So I am asking you the legal question. Why is it unreasonable? I understand the FAA may think it is, and if they finally say so, they're entitled to some deference. So far, we've just got some angry guy writing a memo or a series of memos to you. Maybe not you personally, but to the airport. So my question is, why is it unreasonable discrimination to say, well, planes landing here, that's helicopters, all fine and good, but people falling out of airplanes over nearby houses, we don't have to allow that.
The FAA has been unequivocal in that Grant Assurance 22 applies to this particular situation, i.e. the skydiving operation, because Assurance 22 says that the town has to make available the Chatham Airport for public use on reasonable terms without unjust discrimination to all types, kinds, and classes of aeronautical activities. Skydiving is a clearly recognized aeronautical or aviation activity under the scheme of federal law. Accordingly, should the town decide to preclude that particular type of aviation activity at the airport, that would be deemed by the FAA to be discrimination against a particular type of aeronautical activity. And that's the situation we found ourselves in. When the town did pause or hesitate on proceeding to renew the contract of Skydive Cape Cod, that's when the FAA, shall we say, stepped up the pace in terms of its, Your Honor may consider it to be an aggressive posture, but it pretty much compelled the town to go forward with the skydiving proposal at the risk of facing a formal Part 16 enforcement proceeding.
You did make several.
Go ahead, Judge Meade. We've lost Judge Rubin for some reason, but he will be able to watch the recording afterwards and catch up with what he's missed.
You did make several attempts with the FAA to incorporate some of these safety concerns, right?
That's correct, Your Honor.
And
the town had submitted two separate versions of an RFP within which it incorporated provisions that it felt mitigated some of the risks or potential public safety issues regarding skydiving. We were rebuffed on each occasion to the point where the third RFP, the one that was actually approved and issued, was pretty much, dictated by the terms the FAA required.
Judge Rubin, we noticed that you left us for a little bit.
I will listen back to the final minute and a half on
that. That was my suggestion in the moment.
I think I got the gist of your answer about the FAA being adamant about this.
Okay, thank you very much. It's an interesting case, and a lot. When we open up the YouTube live stream, the clerk will notify me, and I will call the case, and then you may begin.
The case is now being recorded.
Next case on our list for hearing is case number 2019 P 1671, Meade LINDQUIST versus Steve STELLA.
Good morning, Your Honors. May it please the court. I'm Michael Gerasi for Meade LINDQUIST. Your Honors, this is our second time in front of the appeals court on the same case. And in this particular matter, we did brief three issues. The principal one, or the main one, the longest one, is our claim that the trial court did make erroneous fact-finding on finding a violation of the warranty of habitability, specifically with respect to the length of time that the judge alleges bad conditions existed, and by her language that both front and back porches were in disrepair. We don't believe that the back porch, there's enough facts to support a violation of the warranty. We do concede that by the health inspectors, the Board of Health inspection in what we call the March 30 report, there were indeed bad conditions on the front porch, but we believe that the judge had no real factual reason to backdate those bad conditions to at least 2014. And why she chose that year, I'm not sure, or as the defendants allege, back to the inception of tenancy. We suggest that whatever bad conditions existed post-dated December 4, 2015, and were cleared by the inspection of March 29. So somewhere in between that winter into the spring, the bad conditions did happen. And we also allege or argue that the bad conditions did not post-date April 22, 2016, when the Board of Health came back for its final inspection. Instead, the argument of defense is, of course, that the bad conditions extend well into May, but that's flatly contradicted by the documentary evidence. So here, what we're arguing is that the judge, as in the first case, did not grapple with the facts, the inconsistencies, glaring, we would suggest, problems with the defendant's actual testimony.
Can I ask this?
Sure.
I mean, I hear what you're saying, but in March there was sufficient rot in the wood that the stairs were problematic.
Mhm.
We know that rot doesn't happen in a week.
Mhm.
Maybe to the point that's described, it doesn't even happen. I mean, I'm not a scientist. I don't know about, you know what I mean? I don't have expertise in this, but rot takes some time to really set in. And there's evidence in the form of testimony that you don't believe, but still evidence that from the beginning of the tenancy, there was a problem. And the judge doesn't go back to the beginning of the tenancy. She says, look, I'm not going to say that, although I do think there was a problem before, but I'm not going to go all that way. I'm going to say 2014 and tag them with it for 2 years, not since whatever 2011.
Mm-hmm.
How can that be clearly erroneous?
Well, first of all, Your Honor, she ignores the findings of the building inspector dated December 4, 2015, where he noted 3 problems. None of them included rot and required only 2 maintenance requests, to tighten the stair treads and to put a support on a beam, a wooden beam under the porch. So, I mean, if he didn't note all the rot then, how come?
I can't answer that. I know nothing. You know what I mean? But we're talking about sufficiency of the evidence,
right,
to support a finding of fact. And we have one person saying it was like this from the beginning. I see there's all kinds of contradictory evidence. The judge winds up saying all the parties are lying some of the time and telling the truth some of the time. But in the end, how can we second guess those judgments?
Well, I would suggest it's because of all the serious contradictions that exist throughout the evidence. Plus, what basis does the judge have to backdate rot on the porches? And she uses porches in the plural, by the way, and that's, I don't think, supported. But to backdate it to 2014, she didn't grapple with that evidence and weigh it, which is a similar.
She had to. She may not have weighed it the way you would like her to, but she certainly was aware of the contradictions. But as you identified, this is a question of weight and credibility, and resolution of conflicting strands in the evidence. That's a quintessential classic function of the finder of fact. It's the fact that there may be evidentiary support for a different view of the evidence does not require that the way that the judge resolved those questions was clearly erroneous.
Your Honor, I couldn't agree more. You're right about that. It's well within the discretion of a judge to make those determinations. But here, this judge did not show that she's legitimately evaluating and weighing those facts in light of the fact that there are some serious problems with that evidence that really don't support those conclusions. So that's what we're alleging with respect to erroneous findings of fact. And we believe that we've shown just enough here that's not merely inconsistent, but flat contradictions regarding the warranty of habitability. So, I mean, what you're asserting is something that no one could really disagree with. That's our rules. But this particular judge did not really do any of that. I would say that's probably also true for issue number 2, having to do with the quiet enjoyment issue. But I will reiterate, you review those facts. There's nothing to anchor a belief that thought that porch was rotting way back into 2014. And it's also unusual that she did 3 amended judgments that were all over the place. The first one didn't even award damages on warranty of habitability, or even make a finding. Only afterward, defendant comes back with a motion to amend again, and then a third time. So, and she's just flatly making those statements without really showing it. That's what we argue on warranty of habitability. Unless you have questions on that, I would move on, Your Honors. All right, so on the question of quiet enjoyment, the sole issue there would be that there was cross metering of electricity into the defendant's apartment panel in the basement. And the real fact there is that there was no writing that memorialized the cross metering. That's a fact that we concede and don't argue, but we argue that's a health code violation under the CMRs and doesn't necessarily show a statutory violation of quiet enjoyment. In the statute, the cross metering has to come with the knowledge and the consent of the tenant. It doesn't say a writing. And we've got, I would suggest, a lot of evidence here that says the tenant was well aware of cross metering when he came to the apartment to live there in July 2011, saying he knew about the cross metering beforehand, then participating in its enlargement by way of the smoke detectors with the landlord's son. Whoever did the wiring into the panel, his testimony, he was totally aware of it.
But
and I would suggest that also suggests consent.
Again, it seems like this is similar to the first argument, which is everything you're saying is of course true. And if it were us, maybe, and we were listening to the witnesses, maybe we would not have believed his testimony that he never agreed to this. But he testified he never agreed to it, and the judge found as a fact, no consent.
But how could you rightly find that?
Well, by believing his testimony, I guess.
Well, but here's the thing, Your Honor. His testimony that he never agreed to it is flatly contradicted by his testimony that he participated in expanding it and was already aware of it when he moved in.
But the determination of credibility is the sole province of the trier of fact, right?
I'd agree, but where's the evidence that she did in fact grapple with those facts to make those determinations?
She came down on one side and not the other. I mean,
yes, but there's no evidence that she did her job to really do that evaluation, Your Honor.
Look, there's an argument here that another panel of our court sent this back and that the judge just cobbled together whatever minimal thing she had to do to uphold her judgment and not change it.
But she did change it.
Yes, actually she did change it, but not change it in the dramatic way that you're describing. But she makes findings, specifically the finding of no consent in this context, and there's evidence to support it. And in terms of he has knowledge, but he says it was I don't remember who the person he worked with, maybe the landlord's son or somebody, that he's the one who worked on the part of the board that was cross-metered, and you know what I mean? And the tenant didn't. And we might be inclined, we didn't hear them. We might be inclined to find one more believable than the other, or the other more than one. But this is a real limitation of the power of the appellate court, right? Because she's the one who heard them, and she gets to decide who's telling the truth, and she may be mistaken.
Well, I understand what you're saying, but it's the same problem that the earlier appellate panel addressed, that she did not grapple with this information. She didn't say anything about it. She simply went with the defendant's point of view uncritically. And that's the issue. And you have, it's not merely one person.
In your view, what does it mean, and what would the judge have had to have done to grapple with the evidence? I mean, you have conflicting testimony. She doesn't have to lay out in specific detail the reasons why she credits one version and not the other. We've never required that. What she has to do is certainly evaluate all of the evidence and then come down on one side or the other. And she did that. What is it that she should have shown in order
Well,
to
first, okay,
meet your test of grappling?
certainly. First of all, I'm not sure I would agree, Your Honor, that she did that, because there's no indication that she did that. In many opinions, the trial judge goes through points and says, well, here are the facts, and this is why I conclude. She's simply reasserting her original conclusion in the same manner she did before, without any evident reason or justification why. We can impute to her the idea that she's weighing the evidence, but there's no evidence there that she's doing it. And in light of how strong the contrary evidence is, it leaves us wondering if she in fact did do that, or just as before accepted the defendant's assertions.
She can, but she's authorized to accept the defendant's assertions. I mean, I spent a little time as a trial judge, and there were times when I didn't believe witnesses. I didn't put down the reasons in my written memorandum of decision, the reasons why I disbelieved them. I didn't typically even come flat out and say I thought they were lying. I simply found the facts that I credited.
Well, I understand that. And the discretion of a judge to do that exists, but it's not limitless. I mean, when you have some unreasonable results, and we're arguing that these are unreasonable, there's a meritorious issue at hand. Well, all right. The last thing is the attorney's fees, then, Your Honors. The judge simply awarded them their attorney's fees from the very get-go, just to over $9,000. And we think that she shouldn't have done that. Again, there's no showing that there was a violation of Section 2A of Chapter 93. Maybe it's implied there, but there's no showing that there was unfair or deceptive actual practices on the part of LINDQUIST. There just isn't. All the evidence shows she's trying to fix the porches. She did fix the other problems and so forth. Where's the unfair or deceptive actual practices? There's no finding this is true. And the other problem is that those attorneys are not pro bono lawyers, or you have a situation where the defendant is out significant money and needs to get reimbursed. There's no reimbursement here. And I did argue that for purposes of attorney's fees in those statutes, the idea of incurring expenses does in fact mean somebody's out money that has to get reimbursed. And these folks are not out anything because they're hired to do this work.
You saw the defendant's response to the legal services argument in their brief. They seem to be standing on some fairly long settled law that the legal services organizations that provide legal representation at no cost are nonetheless entitled to an award of attorney's fees, right?
Yes, but it says nothing about the fact that they're salaried individuals who are hired to do this very work.
Okay.
And I'm seriously, I mean, if they get reimbursed, if they get attorney's fees, how come that's not an undue windfall? They are paid. They're not pro bono lawyers who are sacrificing their time and efforts here. And of course, they say nothing in their pleadings seeking attorney's fees about the fact that they get salary. Nothing.
Is it? Oh, okay. I see that your time is coming to an end. I have no further questions. Other members of the panel?
No.
All right, Your Honor, I'll just rest on the brief then. Thank you.
Thank you.
Thank you.
For the defendant?
Thank you, Your Honor. May it please the court, my name is Lee Woodruff, and I represent the appellee, tenant Stephen Stella. I'll be very brief, Your Honors, just respond to some issues, factual issues that my brother raised in his argument. I believe that he said he felt that the trial court's opinion grabbed the 2014 date out of thin air or something like that as to when the warranty of habitability breach started, meaning when the rot and problems with the porches essentially became material breaches. And I'd just like to redirect, as from our briefing, the court to the testimony of Stephen Stella and also neighbor Peg Stacy, who testified that around 2013 to 2014 timeframe is when the landlord had asked Stephen Stella to go to Home Depot or somewhere, which they did, and to price out items to make a repair of the front porch. They found that it would cost somewhere around $1,000 and reported that back to the landlord, who said that was too expensive and she would not make the repairs. So the record shows that by 2014, and perhaps by 2013, but the court chose the date of 2014, I think that's conservative, there was a material breach that required those repairs. I'll also respond briefly on the breach of the covenant of quiet enjoyment. The landlord argues that the tenant, Mr. Stella, consented by oral agreement. He cites the Ugal v. Entwistle case, a Mass Supreme Judicial Court case from 2020, to argue that the quiet enjoyment statute does not require a written agreement, and thus that the regulation does not control, the regulation that we cited. But Ugal is inapplicable here for multiple reasons, and I'll just want to distinguish that case factually for the court. In Ugal, the trial court found no credible evidence that the tenant had paid for common area electricity, whereas here it is undisputed that the tenant, Mr. Stella, paid for electricity to light a common hall and a common basement. In Ugal, the trial court found that the tenant had agreed to pay for heat and hot water, whereas here the trial court credited the tenant's testimony that he never agreed to pay for electricity to light those common areas, even in an oral agreement. So for those reasons, the case cited does not control. And I would just direct the court, may it please the court, back to the statute, which says any landlord who transfers responsibility for any utility service to the occupant without knowledge or consent shall be liable. So it's a mandatory liability, and it requires both knowledge and consent. Unless the court has questions for me, I'm happy to rest on the briefs and just once again renew our request for attorney's fees incurred in defending this appeal. Thank you.
Simply then remind you that the case is impounded. Please refrain from reference to any names. Refer to the individual by their status in the case. And if you are watching, if you have been watching the YouTube live stream, please mute your YouTube or turn that off while we're doing the Zoom. Matt, are we live?
Yes, the case is now being recorded.
Okay. The case is case number 2020P602. This is a case involving the care and protection or the guardianship of a child. The case is impounded. I've reminded counsel to refrain from reference to any of the parties' names. With that, I take it, Attorney Morrow, you are going first. You have to unmute yourself and you may begin.
Thank you, Your Honor. And good afternoon, Your Honors. My name is Andrea Morrow. I represent the Appellee Department of Children and Families in this matter. And I'd like to begin by asking this court to affirm the lower court's judgment that mother remains unfit and denying mother's motion for review and redetermination and companion motion to terminate guardianship. In determining whether mother's unfitness persisted in this case, the lower court was tasked with considering mother's more recent successes with her history, and not only her history of inadequate supervision and parental neglect, but also her more recent history of parental deficiencies. And that included her angry and sometimes violent and intemperate conduct towards the child's guardian in this case, which was witnessed at times in the presence of the child, as well as her failure to engage meaningfully and complete certain services recommended by the department, and her failure to appreciate this negative effect on the child, as well as her failure to appreciate the child's wishes regarding custody and visitation in this case, and overall, her inability to assist the child through the transition of leaving grandmother, her guardian's care. These findings, I would argue, are not merely shortcomings that call into questions mother's parenting style, but they're grievous shortcomings that speak to mother's violent character, her angry temperament, and frankly, her indifference towards the child in this case. And furthermore,
has some history of violence herself, right?
I'm sorry, Your Honor?
grandmother has some history of violence herself.
While that may be true, I do believe that the record establishes that mother's violent conduct persisted towards both grandmother and other members of the family. I think there was evidence in the record that this was directed towards.
And grandmother's violent conduct toward the mother was also documented.
That's correct.
Let me ask you this. There is a mistaken finding of fact, I think everyone agrees, about who it was that wouldn't go to family counseling. The judge found that it was the mother and mentions it 4 times in the findings of fact. In fact, it was the grandmother. The judge found that the mother showed no remorse for or understanding of the consequences of having left her child with this person, Ms. Rosa, whoever that is, in 2011, where the child was profoundly, seriously abused and injured. But I don't see any evidence of that in the record of her, maybe you can point me to some, but that she shows no remorse for or understanding of what she did. I don't see that. My question is, given those 2 things, do we have to send this back, or can we affirm despite it? What's your position on that?
So our position was that as to the first issue, that the judge inaccurately found that mother refused to engage in family therapy. We argued that that error is harmless in light of other evidence of mother's unfitness on this issue, including her failure to engage in other services recommended by the court investigator. And that includes the anger management services, the domestic violence services, and those were counseling services that were originally recommended by the court investigator and designed to address her parental deficiency.
See any service plan that she failed to comply with. I know she went to this Stone something, whatever, I don't remember the full name of it, some counseling place. I thought the judge gave her credit for going to that, but then said she didn't benefit from it, but not that she hadn't gone. But that's really not my question. My question is not, well, it might be about some of the other things. I'm trying to figure out whether these 2 things matter. I guess that's what you were answering, but I don't see that she had service plan tasks she didn't complete. But go ahead.
Well, although admittedly the service plan is not before the record in this case, it was clear that based on the court investigator's report, that counseling was recommended to address anger management and domestic violence concerns. Mother did not complete, although she participated in, she did not complete those. That was 5 months in 2014, which was 4 years before this hearing. And additionally, the record did establish that mother did not participate in individual therapy designed to address those problems. Mother testified that she had not seen a therapist since giving birth to a younger child. She claimed to be on a wait list for individual therapy, but had not participated in those services. And then, of course, the judge found that her persistent, angry, and intemperate conduct towards grandmother evinced that she did not actually benefit from those services. So I think that there is evidence in the record as well. You know, grandmother testified that it wasn't that she was opposed to family therapy, just that mother never attempted to initiate it. With respect to the support for the finding regarding inadequate supervision and neglect and mother's refusal to address those issues, I think that as far as that finding is concerned, the court properly considered that as evidence of mother's continued difficulties in parenting her children. There was other more recent evidence that mother left the child alone and unsupervised during visitation. That was in the child's affidavit, where the child reported that mother left her alone with visits during her siblings in 2018, and that on another occasion, mother left the child with the baby.
CF has taken no steps to suggest that mother is not fit to parent the 2 children she's now parenting, right? And your position was that, your actual position, if I'm not mistaken, at trial, was that she should have her child back.
So with respect to the department, the evidence that the court heard regarding the department's position, it was argued in our brief as well. In this case, the ultimate burden of proof regarding unfitness lied not with, the department in this case, but the child who chose to step into the shoes.
That's not what I'm asking. I'm saying, here's this person. The department's position below was she should be reunited with the child. Now you're taking a different position.
Well, the position that the department is taking is that the evidence before the court in this case was sufficient for the court to find unfitness persisted, regardless of where it came from. In this case, the child stepped into the department's shoes and presented evidence, but additionally, the judge was free to consider evidence, including the mother's testimony at the review and redetermination hearing. And I would argue that mother's evidence assisted the court in making the determination that mother was unfit. For example, she testified.
Aside from whether the evidence was sufficient, is it DCF's position that this child should be reunited with her mother?
In arguing, I mean, this is certainly something that was argued by the mother in her appeal, but at the end of the day, the position that the department is taking is that, the court considered evidence of that statement from the social worker, that was the position that DCF was taking in reaching its determination. But the weight and credibility of that statement is a matter that was before the trial court and in the trial court's discretion.
Is DCF the legal guardian of the legal custodian of this child?
Yes, but the court's finding.
The question is this: what is the department's position on the merits?
The department's position is that the court's finding that mother was unfit in this case, despite the evidence, was entitled to deference.
That's not what I'm asking you. I'm asking you what the department's position is on the merits of where this child in its custody belongs.
The department's position is that the mother, based on the review and redetermination hearing, was properly found unfit, and therefore that the child should remain in the custody.
Properly found. So you have changed your position. Is there an internal or formal procedure by which you do that?
There was, in this case,
like a change of goal, like when there's an adoption case or something like that.
Well, in this case,
unification, and is your goal now permanent guardianship?
In this case, the department obviously did not call any witnesses, and at no point did the department move to dismiss the case or join in mother's motions or otherwise move for modification of the original order. So knowing and agreeing with the outcome of the review and redetermination hearing, the department's position is mother is not without remedy here, and the court can consider a request for review and redetermination provided there's no decree against the party, which is not here. So it's certainly possible for the mother to come back in another 6 months, having addressed her anger management issues.
Thank you.
Thank you.
For the child?
Oh, you're muted.
Mother's attorney hasn't argued yet.
Yes.
Who's the appellant here?
Mother's the appellant. I'm sorry. I gotta look at the bench.
Ms. McDonough should have argued first.
I think Maura Kiefer is on next. Is what I'm showing here.
Yes,
Oh, I'm sorry. I called that incorrectly. That's my fault. Attorney Kiefer, please.
Well, I am. Good afternoon.
I'm sorry, Attorney McDonough. I'm sorry.
Honor. Good afternoon, Your Honors. May it please the court. My name is Jaleese McDonough, and I represent the mother in this matter. I think there's no doubt that mother and grandmother have an ongoing tumultuous relationship, and that it spilled over in their conduct in front of the child. And it's also uncontested that the child has established a bond with her grandmother over the several years that she's lived with her. But it's our contention that these factors do not rise to clear and convincing evidence that she is unfit for the court to deny her request to be reunited with her daughter at this point. I want to touch briefly on the child's contention that mother hasn't proved a change of circumstance to even have a review and redetermination. that many of the court's subsidiary findings were clearly erroneous. And then also, even if this court finds that none of the findings were erroneous, that the evidence did not rise to the level of unfitness in this case. As to the change in circumstance, the child's brief seems to confuse the burden of production with the burden of proof. Mother has demonstrated a burden of production to show that she has changed since the child was originally removed. She was homeless when the child was removed, and at the time of trial, she had been living in steady housing for several years. She secured consistent employment. She has engaged in completed programs, contrary to DCF's position. She was in programs for several months at the Elizabeth Stone House, and she continued with services at Room to Bloom, where she was helping her parenting skills in general with respect to her two children that did remain in her custody. She extracted herself from a violent relationship and was currently in the process of divorcing her violent spouse. And she was successfully raising two children on her own at the time of trial, pretty much without any help of anyone. So this more than suffices to demonstrate a change in circumstance. As to the whether the evidence itself rose to the level of clear and convincing evidence of unfitness, the court's finding is essentially boiled down to the tumultuous relationship between mother and grandmother, and the strong bond between the child and her grandmother. In no way were we attempting to downplay the child's injuries. Mother has recognized the child had grave injuries. She relinquished custody to her mother so that her mother could adequately care for her child while she got back on her feet. And it may have taken her a little while to get back on her feet, but she did, and she filed for a review and redetermination. And essentially, the court has tasked her, the lower court has tasked her with completely repairing a relationship with her mother that has clearly spanned back decades of a tumultuous relationship.
Isn't the critical finding here? When she's asked at the end of her cross-examination, what's your relationship with grandmother? She says, we have no relationship. And she's asked, well, isn't that a problem for the child? And she says, no. And right, isn't that kind of the critical piece here? Because of course it's a problem for the child.
Yeah, sure. And I think if you take that one piece of testimony in a vacuum, that could potentially be a problem. But I think we should consider, one, that she's in a high pressure situation under oath in a court setting. But if we look at her actual actions, she was trying to repair her relationship and improve herself. She was actively engaging in services through that point. She expressed that she loves her daughter very much and that she did appreciate that she would need to work to transition her daughter back to her care. So
she said that to the court investigator. I don't know. I feel like I read somewhere that was struck from the evidence, but I don't know, but we have that. But at trial, she says her daughter knows that they don't have a relationship. And so it won't be a problem for her. She knows the reason that it's this way is the grandmother. But that doesn't bode particularly well for the kind of transition that's going to be necessary for a child who's been 7 years with her grandmother as her primary caregiver.
And we understand and appreciate that, Your Honor, but I think she also did express that she understood that it would take a process to transition her daughter back to her care, that she would continue to engage in DCF services to help and assist with that process, and that she appreciated that the daughter would continue to need to have a relationship with her grandmother because of the strong bond that they had faced and that they had established to that point. And I think, you know, the child contends in her brief that essentially the mother and grandmother's relationship is beyond repair at this point, but she's being tasked with repairing this relationship, despite the fact that she's saying, I understand that my daughter needs to maintain a relationship with her grandmother. I understand that I need to help with that transition. But she's being tasked with repairing this relationship with grandmother and her sister, that they don't seem to want to repair it on the other end. So while she's saying that she wants to engage in family therapy, she wants to get individual therapy in order to work out her issues, there doesn't seem to be any give or take on the other side as far as assisting with everyone becoming more harmonious for the care of the daughter.
Ms. McDonough, this is an unusual case from the child welfare cases we typically hear because it does not involve a decree of termination. This was a request for review and determination. There are a constellation of challenges that the mother has in her ability to parent this child safely and effectively. What I'm struggling with is what seems to be at the core of your argument, that we should disturb the determination by the judge at the end of all of the evidence that we've been talking about now for quite some time, that at this particular juncture, the best interest of the child would not be served by terminating the guardianship and returning the child to the mother. That's a heavy lift for you, isn't it?
It is, Your Honor, but I would also note, as far as Justice Rubin's questions to DCF as to whether some of these findings were erroneous that led to the court's conclusion that mother is unfit. As far as that she shows no remorse or understanding of the injuries, or that mother's refusal to participate in therapy, these two findings were at the heart of the court's findings, that mother wasn't making strides towards now being able to care for her daughter. So while it is a heavy burden, and it is, we do look at the trial court's findings with extreme deference, those were two crucial findings of fact that were not supported by the evidence.
But the judge would be allowed, let's say if we were to remand the case back, the judge certainly on the basis of all of the remaining evidence would have ample basis to conclude that this is not the right time to return the child to the mother, right?
I don't think there is ample basis at this time, Your Honor. I think there are still a number of issues with the findings of fact and the ultimate conclusions. They are essentially based on the fact that there's the tumultuous relationship and that there's a strong bond, and adoption of Melvin makes clear that the strong bond must be supported by far more evidence than was presented before the trial court. There was no expert testimony to support the finding, and many of the opinions of the court investigator and the GAL were stricken. There was no complete copy of the reports that the court was considered at trial, but reading the motion in limine in conjunction with the reports, it shows that the findings as far as it being in the child's best interest to remain with the grandmother were all stricken from the record. So it's our contention that the relationship between mother and grandmother, where mother does concede and does understand that child will need some help transitioning, child will need ongoing services from DCF, and that the bond obviously is overwhelming, but shouldn't be the dispositive factor, was not enough for clear and convincing evidence of an unfitness at this point. And that
question about visitation. Visitation is court ordered, is that right? Twice a week?
It is court ordered, yes, Your Honor. It was through a stipulation.
That order remains in place?
It does, but I don't believe it's been complied with.
I agree with that. Is that something where one could get a contempt kind of order so that the visitation can continue?
I believe she could. She does still have trial counsel, and I can discuss that with them, but I believe that it could be a contempt order given grandmother's unwillingness to comply with the visitation order. I believe she testified that she stopped complying once the motion for review and redetermination was filed. She was very upset by it, and visitation ended at that point. So I think to lay all the issues solely with mother also is not supported by the record.
There's trouble. I mean, this is a sad case. These are all terrible cases and tough cases, and obviously there's difficulty in both households.
And Your Honor, if I could just note some of the other factors that were erroneous in the court's findings. As for the fact that mother takes no responsibility in the removal of the child, I agree with Justice Rubin that there was absolutely no basis in the record to support a finding that she took no responsibility, that she was not remorseful. And just because we argued that in our brief does not mean that that mother does not accept responsibility for that. We're simply trying to demonstrate to the court that the cause for removal was not by the abuse of mother herself. She made a very poor decision in leaving her child in the custody of someone else, but she has made strides since then to improve upon that. And then as to the restraining order, the court kept open the evidence to determine what happened with the restraining order hearing. The restraining order was not ultimately issued, but that's not mentioned one time in the entire entirety of the court's findings. There's no support for the court's findings that mother failed to engage in services. They may not have worked to the degree that we would hope, but I think it's clear that there's probably decades of emotional trauma for mother that needed to be undone, that she's still striving and working towards fixing. And our contention is that all these findings went to the heart of the court's findings that mother was unfit. So we would ask that you reverse both the denial of the review and redetermination and the motion to terminate the guardianship. And if the court has any questions, or I can rest on my brief.
Thank you. And again, I apologize for skipping past you at the beginning of this argument.
Okay, no problem. Thank you, Your Honor.
Attorney Kiefer.
Yes, good afternoon, Your Honors. Mara Kiefer for the child. We are respectfully requesting that this court affirm the lower court's decision to deny the motion for review and redetermination and leave the child with the permanent guardian ad litem and maternal grandmother in this case. The child turned 13 years old last month on January 7th. She's 13 years old today. She's been living with her grandmother since she was 2 years old. She thinks of her as her parent, and this is replete, in the record. There's been an awful lot of discussion over whether or not mother made enough progress to establish change in circumstances and to get custody back of her daughter, the child. And the court did credit mother with some strides she made. She attended some classes toward parenting, and she, after 4 to 5 years, did obtain housing, etc. But the court found it wasn't enough. I think this is one of those cases where, because of the passage of time, the child's 13, she's been with her grandmother since she was 2 years old, that it would cause severe trauma if a forced return of custody were made in this case back to the mother. It would cause severe trauma to the child. There does not need to be expert witness testimony to establish that, to affirm the lower court's ruling. There's enough evidence in the record to support the lower judge's findings and conclusions of law with this strong bond in mind. And a couple of the things I can point to as far as the evidence goes, even though the opinions were struck from the court investigator's report, John Howard, the guardian ad litem, he testified at trial. And he had met with the child numerous times over the years, both before and after the motion for review and determination. And he was pretty stable in testifying that the child's expressed wishes never wavered, not once, not through all these years, that she wanted to be with her grandmother. And when he would visit her, she was happy there. She was having a good life. She was excited about school. She was thriving. She was doing well. And the court accepted his testimony as to the state of mind of the child, what the child wants. And she's at an age where, she's not a toddler. She's not 2 years old. She's a teenager now. She was 12 during the hearing, but now she's a teenager. But even at 12, the court is allowed to credit the wishes of the child. And we look to adoption of Melvin to put that into context along with all the other evidence. In the court investigator report, the court investigator did visit collaterals, including the child is still receiving therapy at the rehab center, for her emotional scars, stemming from her injuries when she was a child. She is still to this day going through therapy. And I think this court will have to determine whether or not those opinions were a part of, rightfully struck or not. But that is what everyone who knows the child, who has spent time with the child, is all in agreement that her best interest is served where she is. Now, if you turn to the child, her affidavit was submitted in the trial without objection. So it all came into evidence. And the child, these were her words, and even at that age, and she's pretty clear that she's afraid to go back to her mother. She feels there's a lack of supervision. Her statements are in the record in other formats that one visit, the mother, and I think this is significant, left them unsupervised. And this is what caused her life-threatening injury to begin with, that started this case, that she was left unsupervised. That apparently didn't change. And her mother's behavior scares her. The use of foul language, trying to get into a fight with one of her aunts. The domestic violence hasn't gone unabated. There's no report. The grandmother, is she perfect? No. But I don't think there's anything in the record that the child's been, subject to domestic violence committed by the grandmother at the home or against the child or anything like that. It always seems to be centered on the mother. Do they both have an obligation to try to repair the relationship? Probably. But, once again, I'm going to like to keep repeating that this child is 13 years old today. And she has stated she didn't think it was safe to visit. At the time, she's been.
Kiefer, I see that your time is up. Unless the panel has further questions, I think we'll have to leave it there.
Yes, sir. Thank you very much. Yep.
Thank you all. That concludes our session today.